the submissions made by the appellant, the appellant. The Attorney General began by submitting that the High Court erred by holding that Section 39(2) and 3 of the Act and regulations contravened Article 86 and 138 and were therefore unconstitutional. Focusing first on interpretation of the Constitution, he submitted that the local jurisprudence on interpretation of the Constitution had become uncertain because courts tended to make their determinations on the judicial philosophy of, quote, the best political outcome, close quotes. The Attorney General argued that such an approach was not a proper basis for constitutional interpretation, that a legitimate interpretation demanded fidelity to the Constitution, and that an illegitimate interpretation results in an illegitimate amendment of the Constitution. Citing Interpreting Constitutions, a comparative study by Professor Jeffrey Goldsworthy, the Attorney General argued that judges, unlike other political actors, should be constrained by the laws of interpretation. In his view, whilst both the literal meaning of the provision and the spirit of the Constitution ought to be considered, where the provision is clear and unambiguous, it was unnecessary to invoke the spirit of the Constitution. As far as he was concerned, there were no inconsistencies between Article 86 and 138 and Sections 39(2) and 3. It was urged that in interpreting the Constitution, the correct tools and techniques must be employed based on the honest, transparent and rational reading of the constitutional text. On the authority of, in the matter of Zuma and two others, and the state, and the Attorney General ex rel McKinley versus the Commonwealth, and a scholarly text by Aaron Barak entitled Positive Interpretation in Law, it was submitted that the language of the text of the Constitution must be respected, and were it to be ignored, the result would be divination rather than interpretation. Also cited was the case of Theophanes and Herald and Weekly Times and another to drive the point that it is not legitimate for the court to construe the Constitution by reference to political principles or theories not supported by the constitutional text. Furthermore, it was contended that broad, purposive and normative interpretations should be limited to cases concerning human and family rights, so that in all other cases the court is called upon to do no more than construe the text of the concerned provision. In the Attorney General's view, the language of Article 138(3)(c) was plain in that a presidential election, after the counting of the votes at the polling station, only the appellant was empowered to tally and verify the count and declare the result. We were urged to err on the side of caution by finding that the chairperson of the appellant is the person authorized to conduct the presidential election, to verify the count, and to declare the final result, and that the High Court erred by holding that there was conflict and inconsistency between the constitutional and statutory provisions in question, when that was not the case. At best, he asserted, the alleged inconsistencies were illusionary, and that the High Court and that had the High Court employed the proper and literal interpretation of both Article 86 and 138, it would have concluded that there was no inconsistency between them and Section 39(2) and 3 of the Act. Those provisions, he maintained, address sequential steps that explain a chain of events and are not unrelated episodic events, and further, that whilst voting in all elections is regulated by Article 86, announcement or declaration of the result of the presidential election is regulated by Article 138 and the Act. While admitting that there may be situations when context is important in interpreting a statutory and constitutional text, he nevertheless maintained that the underlying intent of the provision in question is what is important, and there must be a good reason why there is a clear distinction between presidential and other elections, although they are held on the same day. In his view, a presidential election, the whole country becomes one national constituency, and the returning officer for that purpose is the appellant's chairperson. Next, the Attorney General submitted that based on a harmonized reading of Article 86 and Article 138(3)(c), the Constitution prescribes systematic steps which must be accurate, verifiable, secure, accountable, and transparent, culminating in the declaration of final results of a presidential election by the appellant's chairperson. In adding that Article 138(3)(c) empowers the appellant, after the counting of the votes in the polling stations, to tally, verify the count, and declare the results. Relying on Ali Hassan Joho, the Attorney General submitted that the declaration of presidential results involves a plurality of election officers who are obliged to give returns of the results in prescribed forms, culminating in the issuance of a certificate by the chairperson of the appellant. He added that Form 38 is the instrument of final declaration in all other elective positions, which is issued to the successful candidate pursuant to the results announced by the returning officer. Regarding the successful candidate in the presidential election, the Attorney General contended that the certificate issued by the appellant's chairperson was the instrument of final declaration, and that it is only after issuance of the certificate that the computation of time for the filing of an election petition would start to run. Accordingly, contrary to the judgment of the High Court, the declaration by the returning officers at the constituency cannot be final as regards presidential elections. The Attorney General submitted further that to give effect to Article 86, which requires transparency and prompt announcement of election results, Parliament set up a mechanism under Section 39(2) and 3 of the Act for the announcement of results from polling stations, constituency tallying centres, county tallying centres, and the National Tallying Centre. He added that results declared by the constituency returning officer for the governor, senator, women representative, and president are provisional but final as regards the member of the National Assembly and the member of County Assembly. Similarly, in his view, results declared by the returning officer are final in respect of the governor, senator, and woman representative, but provisional in respect of the election of the president. As far as he was concerned, there was no tension between Regulation 83(2) and 3 as was held by the High Court. He submitted that Regulation 83(3) concerned the decision of the returning officer on the validity or otherwise of a ballot paper or vote, whereas Regulation 83(2) concerned the results of the presidential election as shown in Form 34, which are subject to confirmation by the appellant in terms of Article 138(3)(c). He concluded that the confirmation envisaged by Section 39(2) and 3 of the Act and Regulation 83(2) and 87(2)(c is intended to give full effect to Articles 86 and 138(3)(c and is therefore constitutional, contrary to the holding by the High Court. Opposing the appeal, the first, second and third respondents, who are represented by Mr. Otieno, Professor Sihanya and Mr. Oginga, learned counsel, submitted that in interpreting the Constitution, the courts must pay due regard to its values and adopt an interpretation that is both substantive and purposive, while bearing in mind the mischief that the Constitution sought to cure. While accepting that there were provisions of the Constitution best suited for literal interpretation, the said respondents contended that the provisions in issue were not of that kind because they were informed by the desire to ensure transparency at the lowest electoral units. On the authority of the advisory opinion of the Supreme Court in the matter of the Independent Electoral Commission, the trio submitted that the spirit and tenor of the Constitution must inform the process of interpretation, bearing in mind the ills that the Constitution set out to cure. Turning to the question of declaration of results, these respondents submitted that the results of a presidential election announced at the constituency were final and not subject to any changes or alterations except by the election court. In their view, by dint of Article 138(2), voting in the presidential election takes place at the constituency level, where each constituency is required to conduct and hold presidential elections. Under Article 86B, they further urged polling takes place at the polling stations in the constituency, after which the results are counted, tabulated and promptly announced by the presiding officer. Once announced, they contended, such results are final as regards the polling station to which they relate and are thereafter transmitted from the polling station to the returning officer. Article 86C then requires the results from different polling stations to be openly and accurately collated and promptly announced by the returning officers. In the view of these respondents, elections are held in each constituency, and in accordance with Article 89 of the Constitution, Kenya is divided into 290 constituencies. According to them, there is no distinction between presidential and other elections. The polling station is manned by a presiding officer who at the end of the day counts the votes cast and announces the results, which are then passed on to the returning officer. Once this is done, the appellant is obliged to tally the results, which can only be done by the returning officer, who is part and parcel of the appellant. They further submitted that the appellant is a body corporate, operates through its officers called returning officers, and donates to them powers to conduct elections. They added that the locality where the elections are held infuses transparency and accountability to the election process as required by Article 85 of the Constitution, and that at the constituency level, once the results are declared, candidates are obliged to sign declaration forms. Having made such declarations, they submitted it was not open to any other entity elsewhere to alter those results. To do so, they contended, would not only be an absurdity, but would undermine the transparency and integrity of the electoral process. Regarding Article 138(10), these respondents contended that there is a difference between results and result, and that the article provides for declaration of the result of the presidential election, which they interpreted to mean a final outcome, regarding which it is the function of the appellant's chairperson to declare. In declaring the result under that article, they urge the appellant's chairperson does not give the number of votes obtained by the various presidential candidates. On the other hand, they contended results means the total aggregate votes received by each candidate whose announcement is made by the returning officer and precedes the declaration of the election result. Making out their case why the chairperson of the appellant has no mandate to alter the announced results, The three respondents argued that the election materials containing the returns of the elections are retained at the constituency level, and none is delivered to the appellant's headquarters so as to form the basis of comparison and confirmation of results announced by the constituency returning officer. In the view of these respondents, to the extent that counting and tabulation of the votes takes place at the polling station, confirmation of the results can only take place at that level because no recount or retallying can take place at the national level in the absence of the necessary election materials. To purport to recount and verify all votes cast in all polling stations at the appellant's national tallying center would, in the view of the three respondents, be impractical, slow, and in utter violation of Article 86, which obliges the appellant to ensure that whatever voting method is adopted is simple, accurate, verifiable, secure, accountable, and transparent, and also in violation of the constitutional value and principle of prompt announcement of results. To the three respondents, finalizing the results at the polling station and the constituency is consistent with the constitutional principle of devolution under Article 10, and that it is transparent, constitutional, and in the public interest to finalize results at the polling station and the constituency. If it was the intention of the Constitution that the appellant should at the National Tallying Centre confirm or alter the announced results they maintained, it would have provided so in express terms. Turning to the jurisdiction of the High Court to hear and determine the petition, the three respondents submitted that the High Court properly exercised its jurisdiction under Article 165(3) D1 of the Constitution, which confers on it jurisdiction to hear any question on the interpretation of the Constitution, including determination of whether any law is inconsistent with the Constitution. It was their position that the petition did not challenge the election of a presidential elect, and therefore could not have been filed in the Supreme Court. Lastly, on whether the petition was res judicata, the three respondents submitted that issues raised in the petition had never been litigated and determined by a court of competent jurisdiction, and they, as parties, had not previously litigated upon the matter before any other court. It was their submission that the High Court was moved for the very first time in the petition to pronounce itself on the constitutionality or otherwise of the impugned provisions of the Act and regulations, and that Raila Odinga and two others versus IBC and two others did not raise the same issues, as the petition and the parties therein were different from those in the petition. Accordingly, we were urged to find that res judicata could not be raised against the petition. Taking their turn, learned counsel for the amicus curiae, Ms. Nkonge and Mr. Waikwa, urged the appellants concerned regarding reconciliation of electoral materials at the Constitution and national level were taken care of by the provisions of the law, because once the votes are ascertained at the constituency level, the chairperson of the appellant will declare the result and issue a certificate, thereby bringing the presidential election to an end. Central to the petition, they contended, was the integrity of the electoral process. In the view of the amicus, the real issue was not about reconciliation of electoral materials at the constituency and national levels, but the certainty of the votes cast. They maintained that in the event of errors, it was not the province of the appellant's chairperson to make corrections, but rather of the election court. For good measure, they added that the law provided sufficient safeguards against human error in the electoral system. The amicus shared the view of the first, second and third respondents that the appellant's chairperson or its officers cannot, under the guise of confirming, altering at the National Tallying Centre the results declared at the constituency by the returning officer, relying on Hassan Ali Joho versus Suleiman Said Shabal and George Mike Wanjohi versus Stephen Kariuki. The amicus submitted that Articles 86 and 138.2 were clear and unequivocal, and that they did not render themselves to any other interpretation except literal. Turning to the jurisdiction, the amicus submitted that the questions presented in the petition and the relief sought therein directly engaged the jurisdiction of the High Court under Article 165.3 D 1 and 2. It was further contended that the subject matter of the petition was not the validity of the presidential election, but the consistency of a law or regulation with the Constitution. In the view of this party, the jurisdiction of the High Court to determine the consistency of a law with the Constitution was original and unfettered, and could only be exercised by the Supreme Court at first instance where, in the course of determining the validity of a presidential election, a question of constitutionality of a law was introduced and required to be determined by the Supreme Court to comprehensively dispose of the question of validity of a presidential election. It was further contended that even if the Supreme Court had jurisdiction to resolve the issue, that jurisdiction was shared with the High Court, and judicial prudence dictated that the High Court should be accorded the first chance to determine the questions presented in the petition. Lastly, on this issue, the amicus submitted that jurisdiction arises at the time of the institution of the suit and is not lost because of subsequent intervening events, such as the declaration of commencement of election of the President. As regards res judicata, the amicus submitted that the petition was a matter of public interest which should not be defeated by the principles of res judicata. Finally, we heard Mr. Orengo S. Senior Counsel, Dr. Otiende, and Mr. Mwangi for the sixth respondent. It bears pointing out that this respondent did not participate in the petition before the High Court, but instead applied and joined the proceedings of this court with the consent of all the other parties. The sixth respondent took the view that to the extent that the appellant claimed that Section 39.2 and 3 of the Act and Regulations 83.2 and 87.2c empowered it to confirm, alter, vary or verify the presidential election results declared by the constituency returning officer, these provisions were inconsistent with Article 86 and 138.2 of the Constitution. It was further submitted that under Article 86b, it was the duty of the presiding officer to count ballots, verify and announce results at the polling station, whereas under Article 86c, it is the duty of the returning officer to verify, tally and announce the results at the constituency level. The mandate of the appellant's chairperson, it was urged, is to collate results received from the returning officers countrywide and declare the same as required by Article 183.3. The sixth respondent therefore concluded that verification takes place only at the polling stations, that verification of the results cannot be conducted by any other person, and that only verification that the appellant's chairperson can undertake is that provided by Article 138.4. The sixth respondent disagreed with the Attorney General that Article 138 of the Constitution is self-contained, contending that the election of the President, like any other election, must comply with the general principles set out in Article 81, and be conducted generally in accordance with the Constitution. On jurisdiction, the sixth respondent submitted that there was no election, the validity of which was under challenge in terms of Article 140 of the Constitution. It contended that the petition before the High Court did not raise any question relating to the validity of the election of the President held in 2013, and that at the time it was filed, there was no President-elect as contemplated by Article 140. It was further urged that the restriction of the High Court's jurisdiction under Article 166(5)(a) must be understood within the confines of an election whose validity is challenged in terms of Article 140. In the opinion of the sixth respondent, not every dispute in a presidential election is a dispute about the election of the President. Lastly, on res judicata, the sixth respondent submitted that issues in the petition before the High Court and those in Raila Odinga versus the IABC were distinct and separate, and that the Supreme Court did not deliver any judgment on the merit on the issues raised by the first, second and third respondents in the petition. In addition, the sixth respondent added the parties litigating in the petitions and before the Supreme Court were not litigating or suing under the same name or title. Having carefully considered the record, the respective submissions by learned counsel and the authorities cited, we are of the view that there are three issues arise for our determination in this appeal. Namely, A, whether the High Court had jurisdiction to hear and determine the petition. B, whether the matters raised in the petition were res judicata. And C, whether sections 39(2) and 3 of the Act and the regulations 83(2) and 87(2)(c are unconstitutional, null and void to the extent of that inconsistency. We remind ourselves that this is a first appeal, where our duty as spelled out in Rule 29 of the Court of Appeal Rules 2010 is to re-evaluate or reanalyze the evidence exhaustively and to draw our inferences and make our own independent conclusions. As we do so, we pay due respect to the findings and conclusions of the first instance court, but do not hesitate to depart from them if they are based on no evidence or are founded on a misapprehension of the law or evidence or are plainly wrong. Our latitude to depart is even greater where, as here, the petition in the High Court proceeded by way of affidavit evidence, and the court below did not have the added advantage of hearing and seeing the live witnesses in testimony. The first broad ground of appeal is that the High Court did not have jurisdiction to entertain the petition before it. The gist of the appellant's argument is that the issue before the High Court was a dispute relating to elections to the office of President, and therefore by dint of Article 163(3)(a) of the Constitution exclusively reserves the matter for determination by the Supreme Court, and further, Article 165(a) expressly prohibits the High Court from exercising jurisdiction over matters reserved for the exclusive jurisdiction of the High Court. While conceding that the dispute before the High Court did not involve a challenge of the election of a president-elect, the appellant nevertheless contended on the authority of the judgment of the Supreme Court in the matter of the principle of gender representation in the National Assembly and the Senate, that the exclusive jurisdiction of the Supreme Court is not limited to disputes that arise after the conclusion of the presidential election, but extends to disputes that may arise before and during the conduct of the presidential election. To the extent that the High Court declared the statutory provisions and regulations that were impugned before it unconstitutional, the appellant contended that the effect was to alter the process of declaration of results in a presidential election, which has a direct bearing on the conduct of a presidential election. Accordingly, in the appellant's view, the matter was exclusively reserved for the Supreme Court, and the High Court erred by assuming jurisdiction over it. A corollary challenge is that the High Court assumed jurisdiction over the petition because it erroneously assumed that the process leading to the election of the President had not commenced. In this submission, the appellant contended that the High Court appreciated that the dispute was reserved by the Constitution exclusively for the Supreme Court, but erroneously assumed jurisdiction on the basis that the process of the election of the President had not commenced. The appellant submitted that contrary to the conclusion by the High Court, the appellant's chairperson had on 17th March 2017 published Gazette Notice number 2692, setting in motion the process of election of the President to be held on 8th August 2017. The appellant urged us to find that the High Court properly apprehended the factual situation. Had the High Court properly apprehended the factual situation, it could not have assumed jurisdiction. The position of all respondents, save for the fourth respondent who, as we have noted, did not address the issue raised by the appellant on jurisdiction and res judicata, is that the High Court did not err by assuming jurisdiction over the petition. They submitted that the issue raised in the petition was whether the impugned provisions of the Act and the regulations made thereunder were inconsistent with the Constitution. To that extent, the respondents contended that the High Court had jurisdiction by dint of Article 165(3)(d)(1) and 2, which empowered it to hear and determine any question whether any law is inconsistent with or in contravention of the Constitution, or whether anything said to be done under the authority of the Constitution or of any law is inconsistent with or in contravention of the Constitution. In their view, the petition before the High Court did not challenge the election of a presidential elect as contemplated by Article 140 of the Constitution, and therefore there was no basis for the submission by the appellant that the matter was exclusively reserved for the Supreme Court. The amicus added that even if it were taken that the Supreme Court had jurisdiction over the matter, it was a shared jurisdiction with the High Court, and the judicial precedents demanded that the petition be heard and determined first by the High Court. It also disputed the appellant's assertion that the High Court assumed jurisdiction on the basis that the process for the election of the President had not commenced. In its view, that was not the basis upon which the High Court assumed jurisdiction. Lastly, the amicus invited us to find that the High Court had jurisdiction when the petition was filed in May 2016, that the jurisdiction was engaged as of that date, and that it could not be taken away by the subsequent commencement of the process for the election of the President. We would agree with the appellant that the conclusion of the High Court on the jurisdiction is somewhat contradictory. The Court first found that the petition did not involve a dispute relating to the election of the office of the President within the meaning of Article 140. This is how the Court expressed itself, and I quote, "This Court takes judicial notice of the fact that the date of the next general election is 8th August 2017, and therefore a petition to challenge the presidential election can only be filed after the declaration of results following that general election." Close quotes. The Court also found that the petition before it did not raise other issues connected with the election for the office of the President, as would entitle the Supreme Court to assume jurisdiction under Rule 12.1 of the Supreme Court Presidential Election Petition Rules. The Court identified those issues as the validity of the presidential election, declaration of a runoff, qualification of a president-elect, commission of an election offense, or validity of the nomination of a presidential candidate. The Court concluded thus, and I quote, "This Court takes the view that the instant petition does not relate to any of the grounds in Rule 12.2 of the Supreme Court Presidential Election Petition Rules. More specifically, the pleadings in the petition do not raise a question as to the validity of the presidential election, a declaration by the Commission under Article 138.5, the validity of the qualification of a presidential elect, the commission of an election offense as provided under Part 6 of the Election Act, or the validity of the nomination of a presidential election." Close quotes. Later in the judgment, the Court veered from the position it had taken that the dispute before it did not relate to the elections of the office of the President, and stated, and I quote, "In the instant case, the process of electing the President has not commenced. To our mind, a presidential election is activated when under Section 14 of the Elections Act, the Commission publishes a notice of holding of the elections in a gazette and in electronic and print media." Close quote. This begs the question whether, had the Court found that the process of electing the President had commenced, as the appellant submitted it had, would the Court have concluded that it had no jurisdiction to entertain the petition? In our view, having concluded that the petition did not involve a dispute relating to the election to the office of President, and having found that it did not involve any of the matters set out in Rule 12.2, over which the Supreme Court has exclusive jurisdiction, the plunge into the question whether the process of electing the President had commenced added nothing to the judgment but sheer confusion. It gives the impression, as the appellant correctly submitted, that had the Court found that the process of electing the President had commenced, it would not have assumed jurisdiction, which is really not in sync with its first conclusion, that the dispute did not involve election of the President or any other issue under Rule 12.2.
That lack of clarity notwithstanding, we are not hamstrung from determining the issues on its merits. The gist of the first, second, and third testaments of this was laid out in paragraph 4 of the petition, which reads as follows. That the petitioner brings this suit as a matter of public interest, seeking relief for declaratory orders that Regulations 83.2 and 84 of the Election General Regulation are in contravention of the provisions of Articles 86B, C, and 138.2 of the Constitution of Kenya 2010, and that the act of the first person appointing its chairperson as the returning officer for presidential elections is contrary to the provisions of Articles 86B, C, and 138.2 of the Constitution of Kenya 2010. Prior to that, the said respondents had succinctly identified in the petition the jurisdiction of the High Court that they were invoking in the following terms. Quote, the petitioners bring this suit under Article 165(2)(d) of the Constitution,
which grants this honorable court the jurisdiction to hear any question respecting the interpretation of the Constitution, including the determination of 1, the question whether any law is inconsistent with or in contravention of the Constitution, and 2, the question whether anything said to be done under the authority of the Constitution or any other law is inconsistent with, or in contravention of the Constitution. End of quote. Paragraphs 37 to 41 of the petition set out in detail the manner in which the impugned regulations and Section 39, 1, 2, and 3 of the Elections Act 2011 are, in the said respondent's view, inconsistent with the Constitution. They concluded by praying for the 7 reliefs which we have already set out in this judgment, whose crux were declarations that the impugned provisions of the Act and of the regulations were inconsistent with the Constitution and therefore null and void. From the foregoing, we have no doubt in our minds that the first, second, and third respondents' petition was first and foremost seeking determination by the High Court of whether the specified provisions of the Elections Act 2011 and the regulations made thereunder were inconsistent with or in contravention of the Constitution. The other prayers were consequential upon the court finding that the impugned provisions and regulations were indeed inconsistent with or in contravention of the Constitution. Does the High Court have jurisdiction under the Constitution to entertain such a petition? In our view, the answer is in the affirmative and lies squarely in Article 165(3)(d) of the Constitution, which provides as follows. 3. Subject to Clause 5, the High Court shall have D. Jurisdiction to hear any question respecting the interpretation of this Constitution, including determination of 1. The question whether any law is inconsistent with or in contravention of this Constitution. 2. The question whether anything said to be done under the authority of this Constitution or any law is inconsistent with or in contravention of this Constitution. End of quote. Clause 5, to which provision is subject, stipulates that the High Court shall not have jurisdiction in respect of matters reserved for the exclusive jurisdiction of the Supreme Court and those falling within the jurisdiction of the Employment and Labor Relations Court and the Environment and Land Court. The question placed before this court is whether the High Court determined issues that are exclusively reserved for the Supreme Court. Article 140 of the Constitution provides as follows on the jurisdiction of the Supreme Court regarding disputes as to validity of a presidential election. End of quote. Start of quote. 1. A person may file a petition in the Supreme Court to challenge the election of the president-elect within 7 days after the date of the declaration of the results of the presidential election. 2. Within 14 days after the filing of a petition under Clause 1, the Supreme Court shall hear and determine the petition, and its decision shall be final. 3. If the Supreme Court determines the election of the president-elect to be invalid, a fresh election shall be held within 60 days after the determination. End of quote. While a plain reading of the above provision leaves no doubt that the jurisdiction reserved exclusively for the Supreme Court is the determination of whether the president-elect has been validly elected, as happened in Raila Odinga and 2 others versus IBC and 3 others, the Supreme Court has stated that a dispute relating to the election of the office of president may arise even before the president-elect is declared pursuant to Article 138, Sub-Article 10. In its advisory opinion in the matter of the principle of gender representation in the National Assembly and the Senate, the Supreme Court noted that a dispute regarding the election of a president can arise in scenarios other than what is contemplated in Article 140. These will include a situation where there is no president-elect, as in the case where no candidate is declared to have been duly elected under Article 138, Subarticle 4, or where there is a dispute arising in the process of ascertaining the two candidates with the most votes for the purposes of a runoff. The court concluded thus, and we quote them: "It is clear to us, in unanimity, that there are potential disputes from presidential elections other than those expressly mentioned in Article 140 of the Constitution. A presidential election, much like other elected assembly elections, is not lodged in a single event. It is, in effect, a process set in a plurality of stages. Article 137 of the Constitution provides for quote, qualifications and disqualifications for election as president, end of quote, and this touches on the tasks of agencies such as political parties, which deal with early stages of nomination. It touches also on election management by the Independent Electoral and Boundaries Commission, IBC. Therefore, outside the framework of the events of the day of presidential elections, there may well be contested questions falling within the terms of the statute of elections or of political parties. Yet still, the dispute would still have clear bearing on the conduct of the presidential election. 101. Does the entire question concerning presidential elections belong to the Supreme Court's jurisdiction, or is the Supreme Court's power limited by the express language of Article 140 of the Constitution? Besides, a reading of Article 87.2 alongside Article 163.3 suggests, as we perceive it, that the Supreme Court was intended to adjudicate upon all such disputes as would arise from the presidential election. We find no reason to presume that the framers of the Constitution intended that the Supreme Court should exercise original jurisdiction only in respect of a specific event, namely disputes arising after the election, while excluding those disputes which might arise during the conduct of elections, end of quote. We respect the opinion of the Supreme Court that there will be disputes relating to the elections to the office of president that arise even before the election of the president-elect has been announced. The Supreme Court Presidential Petition Rules 2013, and in particular Rule 12, set out some of the issues that may arise outside the strict confines of Article 140 of the Constitution, such as the validity of the nomination of a presidential candidate or commission of an election offense by such candidate. What, in our view, is engaged in this appeal is the relationship between the exclusive jurisdiction of the Supreme Court and the jurisdiction of the High Court to interpret the Constitution. There is precedent from the Supreme Court stating that the fact that a matter is reserved for the Supreme Court does not take away the jurisdiction of the High Court to interpret the Constitution, and in appropriate cases, the Supreme Court will not consider the issue on first instance, but will consider the same in the context of its appellate jurisdiction. In the matter of the Interim Independent Electoral Commission, the petitioner sought an advisory opinion of the Supreme Court as to the date of the first general election under the Constitution of Kenya 2010. Under Article 163, Subarticle 6 of the Constitution, the jurisdiction to give advisory opinions on any matter concerning county governments is vested exclusively in the Supreme Court. The Supreme Court found that the petition before it had properly engaged its exclusive jurisdiction to give advisory opinion. This is how the court expressed itself on the issue, and we quote it. Now, on the facts of the instant case, we would hold that election date is a question so central to county governments as to lie within the jurisdiction of this court in relation to the request for an advisory opinion, close quote. Even after finding that the issue before it was properly within its exclusive jurisdiction to render an advisory opinion, the Supreme Court did not take the view that the jurisdiction of the High Court to interpret the Constitution as regards the date of the first general election was ousted. The Court found that the dispute before it also involved interpretation of the Constitution, which by dint of Article 165 Subarticle 4 is vested in the High Court. The Court was of the firm view that where litigation entails issues of constitutional interpretation, the matter must come in the first instance before the High Court, with the effect that interpretation of the Constitution by both the Court of Appeal and the Supreme Court will have been limited to the appellate stages. It bears to quote in full the Court's conclusion. Quote, in this instance, similar questions entailing constitutional interpretation have been brought simultaneously before the High Court and the Supreme Court, and, as already noted, such a move by parties is apt to precipitate contretemps in resolving the question of jurisdiction. In principle, the Supreme Court commits itself to order and efficacy in the administration of justice, and to that end it may require that the process of litigation commenced in the High Court and entailing constitutional interpretation be exhausted and, if need be, followed by appellate procedures. In such circumstances, this court will be cautious in considering a request for an opinion to ensure the two jurisdictions do not come into conflict, and each case will be carefully considered on its merits. Although the applicant in this instance avowedly seeks an advisory opinion, the application amounts to a request for an interpretation of Article 101 Subarticle 1, 136 Subarticle 2A, 177 Subarticle 1A, and 180 Subarticle 1 of the Constitution, and Clause 9 of the 6th Schedule to the Constitution. As the applicant apprehends conflict in the said provisions, it is to be taken to be seeking the correct interpretation of the said provisions. It is not seeking a plain opinion statement on the date of the next election. We find, therefore, that the question placed before us is not a normal one within the advisory opinion jurisdiction as envisaged under Article 163 Subarticle 6 of the Constitution. The application is still more inappropriate in the light of the several petitions pending before the High Court. The two cases seek the interpretation of the Constitution with the object of determining the date of the next elections. Those petitions raise substantive issues that require a full hearing of the parties, and those matters are properly lodged, and the parties involved have filed their pleadings and made claims to be resolved by the High Court. To allow the application now before us would constitute an interference with due process and with the rights of parties to be heard before the court duly vested with jurisdiction. Allowing such an application would also constitute an impediment to the prospect of any appeal from the High Court up to the Supreme Court. This is a situation in which this court must protect the jurisdiction entrusted to the High Court. End of quote. Ultimately, the Supreme Court declined to exercise its exclusive jurisdiction, which it found properly engaged, and allowed the High Court to first exercise its jurisdiction to interpret the Constitution and the matter, in the event of any party being dissatisfied by the decision of the High Court, to end up before the Supreme Court through the appellate process. In view of the foregoing, we conclude that the High Court had jurisdiction to determine the constitutionality of the impugned provisions of the Elections Act and the regulations made thereunder, and the fact that the first second, and third respondents could arguably have raised the issues before the Supreme Court under its rules, did not deprive the High Court of the jurisdiction vested by Article 163, Subarticle 3D. Accordingly, we are not persuaded that the High Court committed an error or assumed a jurisdiction that it did not have. Turning now to the second broad ground of appeal, namely res judicata. The appellant criticizes the learned judges as having, quote, erred in law and fact in holding that the matters before them did not run afoul of the doctrine of res judicata, end of quote. We have perused the record and note that the issue first arose in the appellant's replying affidavit in opposition to the petition before the High Court. In its first formulation of res judicata as an issue for the High Court's determination, the appellant submitted that the issues that the first, second, and third respondents intended to converse, quote, if looked at properly, end of quote, touched on the 2013 Kenya general election, and that to determine them would be akin to the High Court reopening Raila Odinga and 2 others versus IEBC and 3 others. It submitted further that, quote, the question posed by the first, second, and third respondents on who is the principal returning officer for purposes of presidential election results was answered and or should have been rightly posed, end of quote, in that case. It contended that the issue of tallying in the presidential election was considered in Africa Center for Open Governance, AFRICOG, versus Ahmed Isaac Hassan and another. It contended that the petition was an attempt to bring the same cause of action as previously decided by the Supreme Court, albeit with, quote, a few cosmetic changes, end of quote. The learned judges grappled with the subject, which they styled the second preliminary issue, at some length before arriving at this conclusion, which we quote. It is clear to us that the Supreme Court was not called upon to consider Section 39, subsection 2 and 3 of the Election Act. The Court was not called upon to consider Regulations 83.2, 84.1 or 87.2 of the Elections General Regulations of the Elections Act. The constitutionality of these provisions was not an issue, and neither was the Court called upon to determine that. In our view, the Raila Odinga petition was a time-bound petition brought under Article 140 of the Constitution and which was to be determined within 14 days. It dealt with a straightforward question whether the President had been validly elected. It cannot be reasonably argued that the constitutionality of the impugned provisions ought to have been raised in the Raila Odinga petition. In our considered view, such a challenge could only be done before the High Court, as has presently been done, so that the parties can have, at the first instance, the Court's interpretation of the matter before the parties can benefit from further interpretation on appeal after the Supreme Court. There was allegation that the present petitioners were related to Gladwell Wadhoni Otieno and Zahin Rajan, who were some of the petitioners in the Raila Odinga petition. This claim, however, was not substantiated, and neither was it enthusiastically pursued. To conclude on this point, it is clear that the issues raised in the instant petition cannot, by any stretch of the imagination, be deemed to be the same as the ones that the Supreme Court dealt with in the Raila Odinga petition. We, therefore, find and hold that the present petition is not res judicata, end of quote. That finding has caused the appellant grief, as expressed in its ground of appeal under consideration. Is the grief justified? We think not. Res judicata is a matter properly to be addressed in limine, as it does possess jurisdictional consequence, because it constitutes a statutory peremptory preclusion of a certain category of suits. That much is clear from Section 7 of the Civil Procedure Act 2010, which we quote, "No court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim, litigating under the same title in a court competent to try such subsequent suit, or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court," end of quote. Thus, for the bar of res judicata to be effectively raised and upheld on account of a former suit, the following elements must all be satisfied, as they are rendered not in disjunctive but conjunctive terms. A. The suit or issue was directly and substantially in issue in the former suit. B. The former suit was between the same parties or parties under whom they or any of them claim. C. Those parties were litigating under the same title. D. The issue was heard and finally determined in the former suit. And E. The court that formally heard and determined the issue was competent to try the subsequent suit or the suit in which the issue is raised. The learned judges were fully aware and applied their minds to these elements, applying this court's decision in Uhuru Highway Developers Limited versus Central Bank of Kenya. They rendered the elements as: A. The former judgment or order must be final. B. The judgment or order must be on merits. C. It must have been rendered by a court having jurisdiction over the subject matter and the parties. And D. There must be, between the first and the second action, identity of parties, of subject matter, and of cause of action, end of quote. The rule or doctrine of res judicata serves the salutary aim of bringing finality to litigation and affords parties closure and respite from the spectre of being vexed, haunted, and hounded by issues and suits that have already been determined by a competent court. It is designed as a pragmatic and commonsensical protection against wastage of time and resources in an endless round of litigation at the behest of intrepid pleaders, hoping by a multiplicity of suits and fora to obtain at last outcomes favorable to themselves. Without it, there would be no end to litigation, and the judicial process would be rendered a noisome nuisance and brought to disrepute and calumny. The foundations of res judicata thus rest in the public interest for swift, sure, and certain justice. There is no dearth of learning or authority surrounding this issue, and this court has expressed itself on it endless times. In one recent decision, William Koros versus Hezekiah Kiptoo Komen and 4 others, it was stated, and we quote, "The philosophy behind the principle of res judicata is that there has to be finality. Litigation must come to an end. It is a rule to counter the all too human propensity to keep trying until something gives. It is meant to provide rest and closure, for endless litigation and agitation does little more than vex and add to costs. A successful litigant must reap the fruits of his success, and the unsuccessful one must learn to let go." Speaking for the bench on the principles that underlie res judicata, Justice Y.V. Chandrachud in the Indian Supreme Court case of Lal Chand versus Radha Kishan stated, and we agree, quote, the principle of res judicata is conceived in the larger public interest, which requires that all litigation must sooner than later come to an end. The principle is also founded in equity, justice and good conscience, which require that a party which has once succeeded on an issue should not be permitted to be harassed by a multiplicity of proceedings involving the termination of the same issue, end of quote. The practical effect of the res judicata doctrine is that it is a complete estoppel against any suit that runs afoul of it. And there is no way of going around it, not even by consent of the parties, because it is the court itself that is debarred by a jurisdictional injunct from entertaining such suit. That much was stated by this court in Gogi versus Kinyanjui and 3 others, when it was held that, quote, Section 7 was a mandatory bar from any fresh trial of a concluded issue, and a judge cannot competently get round that bar by obtaining the consent of the parties to an arbitration of a concluded issue, end of quote. The simple question before us then is whether the learned judges erred in their categorical finding that the petition before them was not res judicata, and the answer to the question is a straight no. We have already noted that the appellant in its written submissions did not locate its res judicata objection within the 4 or 5 Section 7 of the Civil Procedure Act elements that constitute it. Indeed, its submission at paragraph 88 was that, quote, the issues that were raised in the High Court were directly related to the issues that were properly before the Supreme Court in Raila Odinga and 2 others versus IBC and 3 others. With respect, that is not what res judicata entails. The issue is not meant to be related, whatever that may mean, to issues in a previous suit. The requirement is that the issue be directly and substantially in issue. It behoved the appellant to demonstrate each of those elements